All right, there has been a lot of buzz within the embroidery community about a certain utility patent. So I know everyone's been very interested in this particular topic. And I mentioned before that I personally was not comfortable really doing a lot of legal analysis about this situation because I am not an attorney. So that's why we have a patent attorney in our midst. This is actually by viewer request. I am really excited to welcome to Sewing Report Live for the very first time. We have Kurt from Uncivil Law. This is super exciting. Kurt, thank you so much for helping us. You're going to help us break down the patent and really explain what this means.
I will do my best.
And you are probably, I think you're like the person for this task. You have a very lengthy history as a patent attorney. All right, so Kurt, before we really get into things, tell us a little bit about yourself and your legal background.
Yeah, sure. So to be a patent attorney, you have to have a technical background. So my background is in computer science. I went to Clemson University, which happens to be ABET accredited, because not all computer science degrees count from all universities. They have to be accredited by a separate institution called ABET. And Clemson's is accredited by ABET. So you have to have some sort of technical degree, physics, engineering, hard sciences, some sort of technical background. With the background itself, you can become what's called a patent agent. And I actually did that in 2004 before I became, strictly speaking, a patent lawyer. So technically speaking, I guess I've been a patent lawyer for 20 years, longer than I've been a lawyer. And then I went to University of Akron School of Law, which has a strong IP focus, and learned a lot about intellectual property law there. And graduated in 2007 and became a lawyer in that same year. So I've been doing patent law, I suppose, or been licensed for patent law 20 years and licensed as an attorney for 17 at this point. So yay.
All right. And if you're not familiar with Kurt, he's actually the man behind the very popular YouTube channel, Uncivil Law. And you're kind of a full-time streamer now. Is that right?
Yeah, I left my employer about 2 years ago because I was getting a little burned out by it. I'd been doing the patent law thing for 15 years. And I was getting burned out. So I left 2 years ago to do full-time YouTube, and it's been going okay.
Yeah, it seems to be going super well. And if you are watching this right now, go subscribe to Kurt at Uncivil Law. Help him get to 150,000 subscribers, because I know you crossed 140K, which is super exciting. And you cover a lot of high-profile trials, high-profile cases. You're doing Supreme Court stuff. And we happen to catch you in between cases right now, because you just finished Karen Reed and you're about to go into Alec Baldwin, which is going to be, are you looking forward to that or what?
I'm looking forward to it because I think it's, depending on how it's argued and depending on the facts, it could be very factually interesting with Alec Baldwin, because the principal legal issue, it seems to me, is his mental state. So he's being charged with involuntary manslaughter. That requires him to have behaved recklessly, which is conscious disregard of a known risk. So the question is whether or not that's true. Did he consciously disregard a known risk? And so I would imagine Baldwin's defense is going to be something like, in the same way I rely on safety coordinators, generally speaking, to make sure my rigging is safe and make sure that, actors are safe and all the rest of it. I'm not a safety coordinator. I'm not a stuntman. I rely on those people. In the exact same way I relied on the armorer who declared it to be a safe firearm. And so I relied on that, and therefore I was not consciously disregarding because I reasonably relied on it. So I would imagine that's his argument. And then I would imagine the state's argument is going to be, he's been told by numerous armorers over the years that it's ultimately his responsibility, and they'll go through the various trainings he's received, plus whatever guidelines apply to him, plus the fact that firearms are inherently dangerous. And so it becomes a battle of this issue, I think. And if that winds up being the issue, then it could be very interesting to see how the presentation of evidence goes and which way the jury lands.
All right. Well, I'm probably going to be tuning into your coverage for that, because that sounds pretty interesting. Plus, it involves a high-profile celebrity. So, and things didn't exactly work out for the armorer.
But she didn't have these defenses.
All right.
Because she is the armorer. She's the guy. right? She's the person who's supposed to be like the gun is safe. But Alec Baldwin is arguably not the guy, because it's like, oh, I can rely on the guy, namely the armorer, who's supposed to be in charge of this. It's like, where does the buck stop a little bit, right?
Yeah,
So
that's true.
The armorer had no working defenses. Alec Baldwin has more interesting chances.
Well, you're giving us a really good preview of your trial coverage here. All right, so we're gonna.
That assumes that they're going to argue along those lines. Of course, they might do something else completely. So we'll see how it actually manifests in the real world.
All right. Well, I'm looking forward to that. So we're going to do sort of a TLDR about this whole, in a whole different realm, this embroidery patent situation. So if you're kind of tuning in and you're new and you don't really know the backstory, there is a patent holder who has a utility patent for a certain type of applique embroidery process. And this patent holder has been contacting YouTube content creators and demanding takedowns of content that the patent holder believes infringes on this particular patent. And a lot of people did not know what to do. And I will show everyone a photo of like kind of what the technique is that the content involves, where the patent holder is like, yeah, you're infringing on my patent. Okay, so let's bring this up here. And now I know, Kurt, you're probably like, do you know much about embroidery, or you have?
Not in particular, no.
All right, so this is kind of the type of content that is being affected, and you can kind of see, and these examples are all over the internet, but it kind of gives this, it's like called, it's a very trendy thing right now. It's called 3D embossed embroidery, or like faux embossed embroidery. And it makes it look like the fabric of the material you are embroidering is like raised up for a 3D effect. So you can see there, and the process that the YouTubers have been using is sort of like main fabric, foam underneath, stabilizer, and then stitching over it to give it that effect, and doing different words, different shapes. People have been selling like fonts with those designs, and the patent holder has been basically saying, you know, you got 2 days to take down your content, you're infringing on my patent. And they've also been offering to license their IP to these content creators. The content creators have been, you know, a lot of these people aren't lawyers. They really don't understand patent law, and they've just been scared. So it does appear that most of these people have just taken down the content because they didn't really want to deal with it. And you can sort of, you know, that seems, do you think that's, for the average person, is that maybe a good thing to do in this situation? I don't know.
Well, I can't give individual legal advice, so nothing I say should be understood as advice to any particular person, because a professional would have to analyze your particular case and your particular issues on an individual level. So it's hard for me to give an answer that will be applicable, but to the extent I can, I mean, it's an issue of risk incentives. So it's like, well, what is the risk profile? And that largely boils down to, well, how much risk do I think I'm incurring from a potential action against me versus how much revenue am I think I'm getting? So is the juice worth the squeeze? So that it makes sense for a typical person to make that analysis, because lawyers are expensive. Patent lawyers are particularly expensive because they require this specialized training. So it makes sense that people would be like, well, it's easier to just give them what they want. That makes sense.
Yeah, and the one lady I talked to had this happen. She was like, you know, it's really not that big of a deal for me. It was only like 1 or 2 videos, and this isn't really her main thing. So she was like, I don't know. And I did get some comments from people saying, this lady's full of it. You should just, you know, ignore the email. And I'm like, that might not be, ignoring it may not be the best course of action. I don't know. And by the way,
you basically have kind of 3 possible categories here once you receive one of these things. So it's like, 1, you give them what they want and they go away. Option 2 is you don't give them what they want. In that situation, one of 2 things is going to happen, or here's what's going to happen. Either you can sue them first, they can sue you, or it's all empty and they don't do anything. Yeah. So those are sort of the possible universes that you live in. So it's like, okay, which of these universes do you like, and what are the risk profiles of those particular universes?
Yeah, and you don't really know what the other person's going to do, so you are kind of rolling the dice with that. So it's like, you can do what you want to do, but at the same time there may be some, there may be some ramifications down the road if you choose to ignore. And by the way, good reminder, quick disclaimer, this video is for informational and educational purposes only. This does absolutely not constitute legal advice. Yeah. And if you have a specific situation, you should seek the representation of a qualified professional. So yeah, again, don't.
I am a lawyer, but I'm not your lawyer. So if you want answers that you can rely on, you need to hire someone and get answers you can rely on. So someone who will go through it in the detail that it would require to give you a formal opinion letter.
Yeah. And that's the thing, like there's so many nuances within patent law and yeah, if you have a specific situation, would you say there's not a lot of like blanket advice that you would give?
Yeah, not really, no. Because it gets down very much into the technical details about exactly what you're doing and the degree to which I can or cannot read that onto the claim. So, I mean, what I'll do is I'll try to give you a very surface level back of the envelope analysis of what it looks like on first impression. But it's like if I were going to do this for real, I'd have to go look at the entire case file to see if there's any representations made by them, any disclaimers, take a look at the office action, see what the going back and forth, see if there's any estoppel from the going back and forth, if there's representations that they can't make. So there's all kinds of things in the file that could potentially change the analysis in some degree. So you have to actually go into the details. And I need to know exactly what you're doing and exactly how. So yeah.
I know. No, that's a good point to make. And I will say this, a lot of folks in the comment section were saying they looked at the patent as non-attorneys. And so this is your more standard applique. So in the examples we showed, it didn't have like a different fabric on top. But a lot of people took the patent to mean that if you didn't have this separate piece of fabric on top, that you weren't infringing on the patent. And we're going to dive into it because that really may not be the case. Yeah. All right, so Kurt has his screen, and we're going to pull it up, and he actually has the patent on his computer. And I'm so excited because I was like, guys, I can't really do anything with this unless I get an actual patent attorney to look at this. And here we are. So this is this is very exciting stuff. Okay, so Kurt, you have the patent pulled up here, and we have he has redacted the patent holder's name. So just at first glance, what are some of your thoughts about this particular three-dimensional applique effect patent?
So the first thing that I always take notice of is the date, is 2015. That's the file date. Because when we're trying to analyze, for example, whether there's prior art or not, that's the critical date. So anything before that date I can use, and anything after that date I cannot use. So the question from a validity point of view would be, do I have art that precedes February 17th of 2015 that either alone or in combination makes this either anticipated or obvious? And if so, then I might have a valid claim to challenge the validity of the patent. But just because it's obvious now doesn't mean it necessarily was obvious then. So, yeah.
And Kurt, you have some pretty in-depth knowledge about the United States Patent and Trademark Office. Can you tell us what happens when somebody files a patent application? What's the typical process that the application?
The typical process, first of all, is it sits around for a while.
Okay.
Because the patent office has gotten more people and they are more productive per person, but the filing rate has eclipsed the ability of the patent office to keep up. So last time I checked, and it's been a while, but they had a backlog of 700,000 applications. So it usually takes a little while to get stuff. When I was dealing with stuff, it was 2-3 years old by the time it got reviewed. The law sort of anticipates it's going to take 3 years from start to finish anyway. There's this built-in sort of 3-year period anyway. So it can take a while. But after it's finally assigned to somebody, it will be given to the examiner. And then what they'll do is they will read this, they'll read the claim, they'll read the specification to understand exactly what's being claimed. And then what they're going to do is they're going to do a search for all sort of technology that is similar. And you can see some of those citations here in the references cited. That isn't necessarily to say everything they considered, but everything at least they're putting on the record, as it were. So the examiner tries to find a piece of art or pieces of art that teach the invention. And if so, then they'll write a rejection to the applicant And then usually the applicant will amend to make it more narrow. And that process can go back and forth for a while, depending on things.
Okay.
So, and then eventually if they agree, you get an allowance and a patent issues. And if not, well, then, it doesn't. So that's the process.
Okay.
It can take a while. It's frustrating.
Since there's a bit of a backlog, what happens are there ever instances where, say, the application finally gets to someone to review it and maybe the information is dated, or does that ever happen? Or maybe since in that time window, maybe there's other things that have come out that are too similar. Would that affect the application at all?
No, it's
okay.
It's frozen in time.
Frozen in time. Okay, that's interesting to know. And another comment I've been seeing on the coverage about this particular situation is folks saying this patent examiner must not know what they're talking about, and they must not know anything about embroidery. What would you have to say to those types of that type of speculation?
So I note right away here on the right hand side where it says primary examiner and then it says attorney. There's only one listed examiner. So the primary examiner is a particular rank, if you like, within the patent office. Usually takes at least 5 years to get there. I mean, that's not a fixed number. There's just, that usually is kind of how long it takes. So, but it does require basically an internal exam that requires being vetted by the patent office. So you can assume that this person's been around for a couple of years, and you can also assume that they've been investigating this technology for their entire career, because that's very typical. The patent office doesn't tend to like to shift people around just for the hell of it. Sometimes they will, as certain technologies become more or less common. But if there's a demand for it, you'll just stay in that technology for your entire career, because they want you to become an expert in it so that you become better at your job. So that's their incentives. So you can assume that this person has been doing this technology for, let's say, 5 years would be a reasonable assumption.
Okay. So would they, in order to be able to work on these types of applications, would they have to have some sort of working knowledge about embroidery, or does a lot of their, a lot of their background just kind of go into this type of, maybe this type of process? Is it more?
Yeah. So the patent office sort of has these big categories, like the mechanical, chemical, electrical arts are like the big ones. So they'll try to match a person's undergrad at least with that sort of master category. So for example, I was computer science, which is a subset of the electrical arts. And so, but I was able to get a position that's directly on point, right? Computer databases and search engines. But they could have put me somewhere else computer related. They could have dealt me with networking. They could have dealt me with memory management. They could have dealt me with a lot of things that were computer related. It was just on the needs of the office. Okay. So you can assume that this person has some sort of technical knowledge in material sciences. Whether or not they've actually done any embroidering themselves, who can say? But they have a engineering degree in this sort of field, and for the last couple of years have been reviewing this. So, you get pretty educated on it.
Okay. And as far as looking over the patent application, what, I know you can't really give a specific time, like how long they spend on the application, but like how much do they vet the application?
Yeah, so it depends a little bit from examiner to examiner, as you would expect. The patent office has something like 8,000 different examiners across disciplines. And so there are just different personality traits, as you would expect. Some grant them more liberally and some grant more conservatively. And it also, of course, depends on the discipline as a whole. So some disciplines are just by their nature a very, very high rejection rate, and some are a relatively low rejection rate. It's just kind of a culture thing. So it's a little bit hard to answer in the abstract, but if you take 100 different people, necessarily one of them is going to be the most conservative and one of them is going to be the most liberal, and everyone's in between, right? Someone's going to be the top 1% because there's 100 of them, right? So it's like so it varies a little bit on that factor. Yeah.
All right. So I saw this and I was like, I don't even know what I'm looking at. Like this could be like a different language for me. But what are some things you kind of noticed? You kind of looked at it when we were talking yesterday, and you kind of noticed some things right away just about like the definitions of what applique is, and like, and you were saying in order to infringe on a patent, the infringer has to be doing the exact same.
You have to have
process,
everything
right?
that's listed.
Okay.
You have to have all the things that are listed, but you can have other stuff. So the way that I like to review this, and again, different examiners would go about different way, and different attorneys would go a different way. Some people look at the drawings first, some people look at the abstract first. The way that I always like to do it personally is by just looking at the claim first, because the claim is a legal claim, like in the same sense as I claim a piece of land, like a prospector, right? It's like, this is my gold, not your gold. I stake my claim in that sense, right? So the claim is the legal thing. Everything else is just verbiage to help describe it, but the claim is the legal boundaries. So like where I'll start is like for claim 1. So it's like, okay, what we have is a method of creating a 3-dimensional effect on an article of clothing. I want to create a 3-dimensional look. Fine. How am I going to do that? It says comprising. So I have to have all these things. I can have more things, but I have to have all these things. And if I'm missing one of them, I don't infringe. So as long as I'm missing any one of them, I don't infringe. Okay, so let's see what it says. All right, first of all, we have providing an article of clothing, at least a portion of said article designed as an area to receive the 3-dimensional effect. Some portion of, let's say, this shirt is going to get a 3D effect. It could be all of it, because all of it would qualify as a portion, but of course it doesn't have to be. Any portion will be fine. So 1%, 100%, any of those things will be fine. Okay, great. Said portion of article of clothing comprising a first side and a second side opposite. It has a front and a back, as clothing does. Cool. All right. Placing an applique on the first side of at least the portion of the article of clothing. So let's say the front side. So I'm placing this applique on the front side. Okay. Placing a structure imparting material and support backing on the second side. So the support is now going to be under the clothing. So the applique comes on top, the support is on the bottom. Okay, at least portion of the article of clothing such that the article of clothing is sandwiched between the applique and the subject and the imparting material, which is kind of what I just said, right? The applique is on the front, the supporting material is on the back, the cloth, the shirt, let's say, is in between. It's sandwiched. That makes sense. Okay, fine. Then it says, such that the article of clothing extends beyond a perimeter of said applique and the perimeter of the said supporting material. So there's at least some cloth that extends beyond the perimeter of the applique. So maybe not so much with that 100% I talked about earlier. Maybe 99% will be fine, because I have to have some margin that extends beyond, because that's what it says. Fine. All right. And then it says applying securing structure through the portion of the article of clothing. So I have to go through the cloth to do this. So glue won't work, for example, because I have to go through it, right? So presumably some kind of thread or some other thing that would be equivalent. All right. So at least through the clothing, the applique. So the thread, let's say, goes through the applique and through the clothing. Said structure material, the thing on the back. So now all three things are sewed together, let's say, such that at least said portion of the article of clothing and said importing material can cooperate to form at least one permanent protrusion. So this is meant to be a fixed thing. So I've got an applique, I've got a shirt, and I've got some sort of structure material on the back, and I'm sewing them together to create this 3D effect. So that's basically how I would interpret that claim. Now, to what you were saying earlier, like you say, okay, what is an applique, for example? What is it? What is an applique? Now, you might have an idea what in your mind that is, but the person, the person who writes it, gets to be their own lexicographer. So they get to define it. So if the specification, which is all the parts we skipped along the way, says it, then that definition controls. If it doesn't, then it would just be what's understood by a person of ordinary skill. So like if I'm trying to interpret a term, the first thing I would want to know is the term defined in the spec? And for example, for applique is. So if I go to column 5 here of the thing, and I go to line, it's line 20 or line 19 here. Okay, it says in some embodiments, the applique 102 comprises thread, yarn, or another embroidery material that are stitched directly into the article of clothing. Mm-hmm. So the applique can now be the thread itself because it just defined it that way. So, because that's what it says.
Exactly. So it doesn't necessarily need to be what we as embroiderers think is an applique, they're defining it as thread, yarn, or other
Yeah.
things. So that to me really changes things. And
Yeah, it makes it broader.
yeah, and the definition, like those examples I showed you guys earlier, I think could meet that definition.
Yeah. And so but also just for way, like if you go a line earlier, like you go to line or go to line 21, it says, like, for example, in some embodiments, a separate applique is not used, but instead the article of clothing itself is shaped into the applique. But this claim doesn't seem to allow for that possibility because it talked about the separate applique, right? So like the spec can give you more than the claim does. And that also would be, that might be the process of negotiation I referred to. So for example, this claim might have started with, okay, I can just, reshape the shirt itself. And the examiner might have went, not so much, I have art for that. Okay. And so they might have excluded that from their claim focus. So the spec might describe more things than what is legally claimed. You can talk about basically anything in the spec, but all that matters legally is the legal claim.
And one thing we both noticed is that the application in the patent does not specify equipment used. So it doesn't say, so it really doesn't, right? Yeah.
It doesn't, it just says to do it. So yeah, no equipment is contemplated. You can do it by hand, you can do it by machine. I'm not sure if there's other options beyond hand and machine, but if there are, any magic will be fine.
Because this could be accomplished with this could be accomplished by hand, with a sewing machine, with a quilting machine, with an embroidery machine. So this process could be accomplished in a number of different ways. So that's where I'm kind of like, that kind of makes it a little bit more, you're like, okay.
Yeah.
Looking at
so that's sort of the back of the envelope. This is not legal advice as it relates to your analysis.
Do you notice anything unusual about this or anything that sticks out, or does it seem pretty standard to you?
I mean, it's written like a patent application, I'll tell you that. So it's written in exactly the same way I'd expect.
Okay.
This is the language I'm used to reading. I read thousands of these things. So this is the right language.
Yeah. So, and again, that's why you're here, Kurt, is because a lot of us really don't understand this. Yeah. So that's why I think it's super helpful. So I have gotten a lot of comments saying, this patent should be invalidated. This patent should have never been approved. Yeah. Like this is, BS. But do you see anything about this that you would say looks fishy or, not really?
So I can't answer that question without reading the prior art because this is not my field of specialty. See, when I did patents relating to computer databases, and I did it for 15 years, I could give you a pretty intelligent opinion because I've read the literature. I know what it says, right? So, but with this, I don't know embroidery. I don't know sewing. I don't know this material sciences. This is not my field. So the only way for me to be able to answer that question would for me to be going to do a search and trying to find examples that demonstrate this. Okay. And if I can find it, then great. And if not, then, not so great. What? Ideally, it would be nice if I could find a single thing that does all the things, because that's what we call anticipated. So if I can find a pre-2015 that shows clearly all these things, and one of the challenges there is dating it, because I have to be able to date it and say, okay, this is definitely from this date. But if I can do that and say, here's a thing that teaches every single thing, then it would be an invalid patent. If I have to put together a combination of things, then the question becomes whether or not it's obvious to a person of ordinary skill. And there, of course, hindsight is something you have to exclude because these things, as you say, are sort of booming now. Yeah. So maybe it was less obvious in 2015. Maybe no one had thought to do this in 2015. Maybe they're the first. I don't know. I'd have to check.
Okay. And the patent doesn't seem to specify, like, as far as like the structure and part of material, it doesn't seem to specify any specific material from what I can tell.
No, like some of the dependent claims give examples.
Type of foam or anything.
Yeah, no. Like some of the dependent claim gives examples. Like Claim 2 says it comprises flexible foam. Claim 3 says polyester base. Claim 4 says multi-layer foam. But anything that would be a structure will be fine. It could be cardboard, It could be, I don't even know what other
Can I
structures
use like
would
a
be.
piece of bread or something? Like if that gives it the puff
Well,
effect?
the bread might be
bread
less
might
than
be-
permanent because it's
Okay.
going to
So
get destroyed in the
Okay,
wash.
so it's
But
got to be permanent. Okay.
at least quasi
Okay.
permanent would be helpful. Yeah.
That'd be kind of an interesting one. How difficult is it to try to invalidate a patent? Like
It's
somebody
reasonably
were-
difficult
Okay.
because patents are presumed valid by law because we assume that the patent office did its job as it's supposed to. So you have to, to invalidate one of these things is difficult.
Any idea like what? I imagine you probably have to have pretty deep pockets and a
Oh, yeah.
willingness to commit yourself to this process if you wanted to make a go for it, right?
Yeah, I mean, depending on how hard we want to fight, these fights can get incredibly expensive.
Yeah.
Because there can be a lot of money in it depending on the patent. And, people will fight at least as hard as their economic incentives will allow them to fight. So if you're, going after a patent, but there are big battles sometimes like Microsoft versus Oracle or things like that, dealing with the iPhone and the rounded corners of the design, Samsung versus Apple. So sometimes you have patent fights that involve trillion-dollar companies, and then things get really exciting.
So in an interview we reacted to where you were talking with Eric Hunley, he was
Mm-hmm.
asking you about patent trolls.
Mm-hmm.
How common is that type of thing within the industry?
So the patent office prefers the term non-practicing entity because it's less judgmental. How common it is, it depends on a lot of things. But from first principles, there's nothing wrong with it.
Okay.
Because the entire point of patents is I give you a monopoly in exchange for the technology. You have something I want, the technology. This is new, and I want the technology. So what incentive do I have to get you to give it to me? Okay, what I'm going to do is I'm going to give you a monopoly. So you have the exclusive right to the thing. But it's your right in the same way that if you bought a piece of property, it's your property. If you want to choose to leave that property barren, then that's your property. If you want to choose to farm on it, that's your property. If you want to build a house on it, that's your property, right? So you have the right to not do things. So assuming the patent is valid, then I would say that a person saying, well, I'm not practicing it. I've done what I'm supposed to do. I've told people how to do it, but no one's allowed to do it for 20 years. And I'm allowed to sit on that and, pay me. So that's, I would say that that's a valid thing to do with property, just like any other kind of property.
Okay. And how long are patents valid for once they're issued?
There's 20 years from the date of filing.
Okay. Okay. So the date of filing. Okay. So 2015. So it would be 20 years from there.
Yeah, I think
Okay.
in the thing it said it was adjusted to 2038 due to some
Okay.
delays or something like that. So the actual date is on the patent office, but yeah, 20 years is the date from filing.
Okay. Super interesting stuff. And that's, it's like a lot of people may not like certain things, but that doesn't make what the person's doing wrong. Like in the non-practicing entities
Yeah.
situation, they're within their rights and they're acting within the law. People may not be thrilled with it, but
Yeah.
it is what it is.
And also, like, if you want to think about it more from an equitable perspective, you could imagine that a person might get patent, but not necessarily the money to actually practice it. They have trouble putting together the financing, for example. So you don't necessarily want some creator out there who's like, well, I've come up with a new thing, but I can't actually get the money behind it. And then, big corp comes in and be like, oh, that's okay. I'll make a whole bunch of them. It's like, okay, so what remedy is this person supposed to have? It's like they can't make them, but big corp can. It's like, should big corp be allowed to get away with that? It's like, I bet you think the answer is probably not. It's like, this is this small person's property. That's their right. Big corp has come in and stolen it, and they deserve to be paid. But of course, in our system of law, we have equal justice under law. So if you say that is true for the big corp versus small corp, it has to be true the other way around. Because we don't ask those kinds of questions. We want everyone's rights to be the same. The land belongs to the rich person or the poor person alike. If it's theirs, it's theirs.
All right. So I think one particular aspect that has people kind of upset about this whole thing is that the patent holder appears to be going after people that they perceive as sort of weak and lack resources to be able to fight this particular situation. If you hold a patent, is there anything that, anything where you kind of have to enforce it equally, or can you kind of do selective enforcement?
So for the sake of clarity, I'm not going to make any characterizations about the person who owns this patent to what they are doing in terms of, whether it's legal or not, because I can't even, as I say, to give a formal legal opinion on this, I would actually require quite a bit. So, I'm not going to analyze it from that perspective. But in terms of your question, no, you do not have to enforce it evenly. You can choose to enforce it against everyone or not as you wish. Because again, it's your right. If you want to let people on your land, that's cool. You don't have to, and you're a private person, so you don't even have to be equitable about it. I can choose to discriminate against you for any reason that crosses my fancy. I'm not the government. I can do whatever I want. It's my thing, right? So.
All right, I'm not gonna lie, Kurt. Some people are probably going to be kind of upset with this, with this video, but that's the thing. This is the law, and that's why I had you on, is to not necessarily tell people what they want to hear, but to tell people what the law is from someone who has expertise. And the other aspect is the whole content creation aspect. And it's interesting because when I first heard about this, I was like, in what world, is this a thing? Could patent protection extend to digital content, something like a YouTube video? That's not anything I would have ever thought content creators would have to really be concerned about.
Well, to the extent that you're practicing the invention, which is to say that you're making the thing, then you're violating the patent. The fact that you're filming it is neither here nor there. You made the invention, so whether you're filming it or not is irrelevant. The other thing that will be a bit of a shock to people is in patent law, there is no concept of fair use. So in copyright, I'm sure you guys have heard about fair use a lot. The idea about whether or not a person can use another person's video or song or whatever. There's a whole fair use analysis in copyright law. There's a fair use analysis in trademark law, but there is no fair use analysis in patent law. There's no such concept. So if you make the invention, you can't be like there's fair use because the concept doesn't exist.
All right, mind blown, Kurt.
Yeah.
And just to be clear, you don't even have to be necessarily selling
No, just mere making will be fine.
You just have to be making it, right?
You just have to make the thing, right?
So
as long as you're practicing the invention, as long as you're following each and every step, you're there. Whether you sell it or not, whether you video it or not, you're there. And then the only question at that point is damages, obviously. Okay. So the more damages that there are will inflate the dollar amount. So they won't be equal from a monetary standpoint in terms of how much penalty there is. But for underlying liability, the fact that you did it means you're civilly liable. For how much, we have to know a little bit more. But
Woo. Yeah, and that's interesting because a lot of folks were saying, hey, if you're just showing people how to do it and you're just teaching, then you're kind of immune from things, but you're saying that's really not
that's
the
not
case.
No. It's just So, but now what I will say is just for the sake of clarity, what the normal way to take down a video is through a copyright strike, the DMCA, the Digital Millennium Copyright Act. The word copyright is right in the name. So there is no automated takedown with respect to patent law like there is in the DMCA. So YouTube, by law, basically has to take down videos relating to copyright infringement in order to get safe harbor. If they want to not get sued, they have to take it down. But there is no process for an automated takedown in patent law. So they could say, no, I'm not going to do that. And they presumably would not be liable, but YouTube can choose to, because YouTube can choose to moderate anything for any reason they want to. So if they choose to remove it as a matter of their own policy, that's their call, even if it's not legally required.
So if the patent holder maybe, and again, I know some people who in a different situation had videos removed due to legal complaints by a third party. So the patent holder could be that third party and ask YouTube could they ask YouTube to take down the content?
Yeah, they certainly could. And if I was YouTube's counsel, I probably would say yes, because I want to minimize any potential issues for my client. That's my job as YouTube's lawyer, right? So it's okay, this person says take down this video, they're alleging patent infringement. It's well, how much is it worth to me? Not that much. So it just becomes easier to say, okay, fine, and I'm not going to fight it. It's not my problem. So, that's the most conservative decision you can always make.
Yeah, and we've seen time and time again as content creators, YouTube does tend to be very they definitely err on the side of caution in terms of content moderation. And that's crazy to me because I'm sure as a patent attorney, I just would never have thought like, hey, if someone's doing a patented process in any area that a patent holder could come after a YouTube video.
Yeah.
But
I can talk about it. I just talked about it in extensive detail. It's like I read the claim and I walked you through it and I explained exactly what it is. The patent itself is not copyrighted. It's a government issued document. So there's no copyright in the document. It's a US government work. 17 USC 105, no copyright because it was produced by the US government. So there's no copyright in the patent itself. I can talk about it all day long. I can show you the patent. I can talk about it. I can show you the figures. I can explain it. I just can't actually practice the invention. I could even do it like in software because I could actually like show it to you graphically or something. I just can't actually physically do it.
Okay, so we're not going to order you an embroidery machine and have you demonstrate the patent. Okay.
Well, that's a bad idea for any number of reasons.
Okay, all right. Maybe hey, maybe this is something that could be your new thing. I don't know.
You think?
You could do it. I've noticed you sometimes have some downtime on the stream, so you do other stuff. This could be one of your new hobbies. I saw you playing Legends of Zelda. Come on, I feel like you could, maybe expand the horizon. I saw your chicken dance, Kurt. I did see.
Yes,
that.
The chicken dance was real. I was celebrating the end of Chevron versus NRDC, a case I loathe.
And sometimes you even wear a cowboy hat on.
This is true. I do wear a cowboy hat a lot.
So yeah, your streams are very fun, by the way. I do enjoy them. And, I just enjoy, I'm just a big Law Tune fan overall. I know there's been some turbulence lately in the sphere, but it's definitely, it's provided me many hours of informational entertainment. So I really appreciate everyone in LawTube. And, I'm just so excited to be able to talk to someone who's within the space. So yeah, you do a lot of, maybe the embroidery, no. Okay. A lot. You can do the chicken dance while you're.
You can do the chicken dance.
Making a mama sweatshirt.
I can talk about Supreme Court. I'm pretty good at talking about Supreme Court. I can do that.
You could maybe embroider some Supreme Court, type stuff for yourself. I don't know. Because I did see you sell some merch. You do have some merch.
This is true.
Available. So you're getting into the custom apparel space a little bit. So maybe we can
handmade by Uncivil's going to be a reward tier.
Oh man, you could charge a lot of money for that stuff. You make it on the stream and then you package the orders and stuff.
There's potential there somewhere.
I really think there is. Well, yeah, that's crazy because I've seen some other videos and comments where people are like, yeah, there's no way, you're fine. It's a YouTube video. They really can't come after you with a patent, but you're saying that information is not really right.
I'm saying that assuming that you are actually manufacturing the thing by following each and every element of it, then that's a patent infringement. That's true regardless of whether it's filmed or not. If you're filming it, then you're filming yourself committing the patent infringement. Yeah. So that's true. And again, I take no position whether or not for any particular person or any particular seller, they are or are not infringing, right? That would require a more robust analysis. I've given you a very back of the envelope, cursory analysis. To do this for real, I'd really need to go into the file. I need to look at the art. I'd actually need to look at a lot more things to figure out exactly what's going on. And that would require, a fair amount of money. Yeah. So, I don't take any particular position as to whether or not this patent is or is not valid. I don't take any position as to whether or not this patent owner is doing anything legally wrong. I can simply say that if it were valid and if the person is doing the thing, then that would necessarily be patent infringement because that's what that would mean.
Okay. Have you ever heard of a patent holder coming after YouTube videos before?
No, I don't think I've ever heard of that before.
Okay. So do you think that could be an issue in the future? This is the first time I've ever heard of anything like this happening.
I don't know. I mean, but people misuse the system all the time. I've seen people file DCMA claims for trademark infringement. And it's that's not what the letter C stands for. You can't file a DMCA claim for trademark. Those are not the same thing. So it could be a confusion over what these issues are, because as I discussed in my video with Eric Hunley, the exact boundaries between patent, trademark, and copyright are somewhat poorly understood, and people use the terms inappropriately all the time. So it could be a confusion thing. It doesn't necessarily require any malice.
No, that's true.
Especially if it's like just a random person doing it themselves, the actual person, the inventor. If it's just the inventor like doing it themselves, they don't necessarily have the sophistication that a patent attorney would have to know whether or not their claims are necessarily valid. It doesn't mean that they aren't valid, but they wouldn't necessarily know for sure because it's complicated.
Do a lot of patent holders attempt to enforce it themselves, or do they?
No, God,
use
no.
A lawyer. Okay.
God, no.
Is that unusual that they're kind of DIYing this?
Yeah, that's pretty unusual.
Okay. Is email an acceptable form of community? Like, because some people are like, okay, well, they didn't send it registered mail or anything. They just sent it email. Is that like...
For an informal thing, they can do any communication method will be fine. I mean, they're not trying to meet the requirements of some statute with service of process. So, if they send out a tweet and you get it, then sure, why not? That's just a demand letter.
So but that's a valid form of communication. Okay.
Yeah, I will point out though that if it's a demand letter, you could sue them in principle, because now you have a valid cause of action for declaratory relief, right? You can't just sue in general, but if this person sent a cease and desist letter to you as like cease and desist this, and you can be like, not only am I not going to do that, I'm going to sue you first. So that is an option. An expensive option potentially, but it would be legally valid.
Yeah. Well, and unfortunately, a lot of people in our community really don't have the type of resources for legal expenses. And that's why most of them have decided to just comply and do what this person has asked. Obviously, a lot of people don't really want to pay the licensing fees, so they kind of just wanted to stop doing this type of content. Sure. So it seems like this is sort of, and again, this was sort of just a trendy thing anyways. So it's, most people that have been affected, there is one person that was selling, at least one person that was selling fonts to do this. So like digital fonts. And that person decided to take down all of that, make that unavailable for sale after they were asked. So yeah, this is pretty crazy. This is a real barn burner. That's for sure. I think people are going to be very surprised by what they've learned during this conversation. Do you find like when you and I know you were kind of saying in the other interview, you tend not to talk about patent stuff a lot because it's just so easy to get into the weeds. But is there anything else that you think people should know about patent law that most people get wrong?
Well, obviously, a U.S. patent's only valid in the U.S., but that's true for any intellectual property right. That would be true for a U.S. copyright or a U.S. trademark would only be valid in the U.S. So this patent, by its own terms, does not apply in any other country. There's that. The only other thing I would sort of note is just that, you have to really understand. It may be the most pedantic field of law. It is trying to describe sometimes an abstract concept in legal language. My own field of computer databases is arguably even worse for this, because at least here you have a physical object that could exist and you could actually go look at the thing. With computer databases, I'm already dealing with an abstraction anyway. It's like, how do I go look at a computer database? I really can't. So I'm trying to describe legal language to describe an abstraction, which is itself an abstraction. So trying to figure out what it means is incredibly pedantic. So if you like actually, then patent law might be for you because it's incredibly precise.
Also, I heard a rumor that you absolutely love chemistry, right?
I hate chemistry. Chemistry and I do not get along. I do not understand a chemical patent, and I don't understand chemistry in general. I couldn't even balance equations, in high school. I'm good at math. I was on the math team, but the chemistry eluded me. So yeah, if you put a chemical patent in me, I'm just bowing out.
Your passion about your hatred of chemistry is.
I wouldn't say I hate it. It's just that it eludes me. I don't understand it. I'm not competent to talk about it. I don't think I did too well
in that subject either. No.
Physics, I can do fine. Mechanical, I can do fine. Electrical, I can do fine. Chemistry, no.
No, I'm not really a science person, so that's not really my Yeah, not really my wheelhouse. Well, Kurt, thank you so much for joining us to break things down. This has been incredibly enlightening, and yeah, a real barn burner episode. I think our comment section is going to be pretty lit.
Yeah.
That's for sure. Guys, but be respectful, be polite in the comments. And I'm going to ask you, please don't do the armchair legal analysis. It's not helpful. And, you could really mislead people. So we're going to leave this to Kurt's expertise.
And also do not contact this person directly and harass them. That's just bad all around. First of all, harassment's illegal, so please don't do that. And it's just bad. It just leads to further problems. So do not try to reach out to this patent holder and, for the purposes of harassing them. That's just bad idea all around.
Yeah, no, thank you for mentioning that. Yeah, because a lot of people are very upset about this, and that's why I specifically chose not to reveal their information.
Yeah.
Again, we don't. I know people have been very opinionated about this particular subject. But
I'm sure people will have many thoughts about whether or not this technology was known on February 16th, 2015 or not.
Yeah. So I have people in the comments, they're trying to find books, so I mean, is that
Sure, yeah. Anything I can date.
Something?
Anything I can date. Any publication, object, anything I can date that I can say this is from this particular date will be great. It can be a physical example. It can be it can be a paper. It could be a presentation at a conference. Anything that is published that exists will be fine. But the challenge is finding the date.
Yeah.
So I can be like, okay, this thing is this date. Usually with papers, that's easy because they're dated. But if you're like, here's a physical object, it's like, okay, can you show me that this object was created before this date?
And then beyond that, you're going to need to have the resources to, get a lawyer and try to fight this. So,
yep.
It's not, I got people saying, we should try to fight this. I was like, I mean, you can, if you want to put some money up and try to spend some time working on it. But, it sounds like it wouldn't, it kind of wouldn't be like a real easy path.
No, it's incredibly expensive.
Okay. Yeah, and I know I don't have the money for that, so
But yeah, this patent holder may be in the legal right. They may not. It would require more thorough discussion. So, but at least you have a sort of framework to try to begin to understand what this language is talking about. Make sure to read the claim and then go read the specification to see if it has defined terms, and then try to figure it out from there. And the broadest reasonable understanding is the correct interpretation.
Okay.
So in the broadest reasonable understanding by a person of skill in the art. So someone who knows what they're talking about, how would they understand this in light of the specification? It's a lot of qualifications.
I have to say, I'm so glad we had this conversation because, like most of the viewers out there, I kind of had a certain viewpoint going in, and now I have a different, I'll be real, I have a different opinion now. So
I'll give you a completely different example where I had a different opinion versus like the general public. So there was Uncrustables, the peanut butter jelly sandwiches. The people that came up with Uncrustables tried to file a patent for the Uncrustable, and there was a whole dispute at the time, in the chatter on the internet that's like they're trying to patent the peanut butter and jelly sandwich. It's like, well, no, not exactly. They're trying to patent an exact way of making a peanut butter and jelly sandwich. There's a exact way that they're making it, and they say that this is to achieve, among other benefits, to prevent it from getting soggy, and so that they want to assemble a peanut butter and jelly sandwich in exactly this way. I was like, okay, well, that is solving purportedly a problem, that it's getting soggy, and how do we prevent that? If we do it exactly this way, it prevents it from getting soggy. So that would be useful. Now, whether or not anyone had made a peanut butter and jelly sandwich that way before, I was like, I don't know for sure. But the idea that the patent was ridiculous on its face, I disagree with. It's like assuming no one had made a peanut butter jelly sandwich that way before, and they were the first ones to do it, then they've come up with something useful. They've come up with a new peanut butter jelly sandwich of a new design, and it is useful because it achieves a desirable end. So, that would be great.
Hats off to the Uncrustables people, because those are really good.
Right?
There's something about the Uncrustable. It's kind of addicting. There's just something about it. They did make a very special way to do it.
See,
That's
this
a
is
really
what I'm
good
talking
example.
about.
Oh.
Maybe no one had ever done it exactly that way. Maybe it was not obvious before. So maybe they were right. I don't know. I'd have to go check.
I mean, it's kind of, it is kind of genius. It really is. No, I can't help but ask you, does it ever kind of drive you crazy to see people who don't know what they're talking about patents? Like, does that?
Well, that's just true of law generally speaking, to be
Okay.
honest.
When you see all the comments, people are like, you're wrong or whatever. Like, are you like, and what's some like really bad? Have you ever seen like someone give like the worst armchair? Like, what's the worst type of armchair legal analysis?
I don't know. It's hard to say what the worst is, but the like over application about what it is, right? So the peanut butter jelly sandwich crustable is a good idea, right? So they see this and they're like, oh, they're trying to patent the peanut butter jelly sandwich. It's like, that's not exactly what's going on. Or in my field, right, there was what I used to call like the ubiquitous figure number one, right? Because it would show a computer, attached to a network and a hard drive and all the rest of it. And it's like, oh, this is the ubiquitous figure one. And they would have descriptions in there about, a computer is this, which would have the description of what a computer is. It's like, oh, they're trying to patent the computer. I'm like, no, they're really not. They're just trying to provide enough technical understanding for what they're going to claim. So the over understanding about what's going on is sometimes challenging. Patents don't necessarily have to be big, and sometimes they're very small. But then again, small things can be useful. They don't necessarily have to be a huge deal. Minor changes are technological change, and that's all you really need is it to be different. Not necessarily better, by the way, different.
In your opinion, is it more difficult to get a patent now than it was maybe like 50 years ago? It just seems like there's so many things coming out. Like, is it, as time goes on, is it harder to get new ideas?
I don't know. I suppose to some degree it depends on the maturity of the art. So some arts have been around a lot longer than other arts. So like, for example, if you're trying to develop a new kind of coffin, and yes, there is such a thing as the coffin arts. There are people at the patent office. What they would do is they review coffins. No lie. So if you're trying to come up with a new kind of coffin, it might be a bit difficult because coffins have been around for a while. But if you're trying to come up with a new kind of database, maybe less so because they haven't been around that long. And the field is evolving constantly. The rate of technological growth is immense, as I'm sure anyone who's paying attention will notice. So yeah, in some ways it depends. In some ways, no. There's a lot more being invented, but in some ways there's a lot more to invent. So it depends on how mature the technology is that we're trying to discuss.
That's true. As there's new AI stuff or new kind of sectors of tech, there's going to be new. So there's going to be new. And is that something you really like about patent law? Is just you get to see all the new ideas. Like, what do you like about this particular area?
I think if I had to say what I like the most about it is maybe it's the most objective and the most scientifically rooted, that it is the least dealing with feelings because it's technology. It's like it's the one least prone to how you feel, as opposed to other fields of law which are more about how you feel. Like for me, the extreme opposite would be family law, because that's largely about how you feel. Especially if you're talking about children, what's in the best interest of the child, right? So to my mind, and another attorney might disagree with my characterization, but to my mind, like family law is the most chaotic because it is the least moored from, what I could understand as a tangible legal principle. And it's much more dependent on the feelings. So patent law, along maybe with tax law, sort of the extreme other end. It's like, we literally don't care about your feelings. This is technology. We don't care about how you feel about anything. This is unmoored from the human frailties, perhaps as any other field of law is. So that's nice.
No, that's cool. Well, I got to ask you too, on a personal level, Kurt, what has it been like for you to go from more of a practicing attorney to doing YouTube? Like, what's that been like for you?
I've been happy. One of the reasons I left my job was just because, and this sounds so arrogant every time I say it, but I don't know how to say it any better. It's like I basically got to the point where I knew everything within my little domain. Because as I sort of mentioned earlier, you get hyper specialized, because the more specialized you get, the more knowledgeable you get. And the more knowledgeable you get, the better you can do your job because you know more things. So basically within the scope of 15 years, I got to the point where, I got narrowed down and I basically knew everything, and there was nothing left to learn. And so I was incredibly bored. It's one of the reasons I don't talk about patent law. Not only is it technologically complicated, but at least in my own field, there's nothing interesting anymore because it's all sort of variations on a theme. But I really like, being a content creator because I can talk about any field of law I want. And often I'm learning something new because I've never known about that field of law. So I get to learn a new field of law. It's great.
No, that's awesome. I'm so happy to hear that. And I'm really glad. I've actually kind of followed your growth over the past few years. It's really cool to see people grow on YouTube. I think this is a great space. I love doing this. I do it full time as well. And, this is like the best thing I've ever done. And it's just awesome. You get, and you also get to call the shots. You get to decide like how your channel is run. And I'm having a lot of fun. I got to ask though, so far, what's been like do you have like a favorite case you've covered so far? Or what's like the one that's, been the most interesting for you?
Well, the chicken dance one's pretty good with overruling Chevron. I hated that case so much.
You seem super jazzed about that.
I hate that case.
Okay.
It is my least favorite case in my lifetime. I hate that case so much. I've been railing against that as long as my channel has existed. I hate Chevron versus NRDC. It was a case dealing with deference to the administrative state. Basically, it allowed the federal government's administrative branch to interpret law. And I'm like, no, that's not what they're supposed to be doing. They execute the law. They don't interpret law. The judiciary is supposed to interpret law. But it basically gave the power to interpret to the executive branch. I was like, this doesn't make any sense. And it drove me crazy. And they finally overruled the case. And I chicken danced because I was so happy. And I sang. And I even twerked on stream for a little while.
Oh my gosh. Okay. So is that what
I twerked for the end of Chevron.
Okay. And I saw you on a stream say that it was like Christmas for you.
Yeah.
It was like Christmas.
Yeah.
So that was a pretty,
so
you must have been pretty jazzed about that.
I'm pretty jazzed.
Okay.
It died
awesome.
horribly, and hopefully will stay dead forever.
Oh my gosh.
I hate that case so much.
How did you get into like all the Supreme Court stuff? Like,
I've always been interested in that
so you've
subject, to be honest.
It's just been kind of an interest you like. Okay.
Yeah, it's kind of how I started getting, I got interested in law. Literally, I got interested in law because when I was about 4th grade, I found a pocket constitution. It was just lying around somewhere. And I read it and I was fascinated by it. And so my fascination has continued ever since. So I've always been interested in the Constitution and constitutional law. It's one of the things I know a lot about, even though I've never really practiced in that area. I love all the decisions. I love reading all the decisions. It's like I know the literature pretty well. Most of my fellow compatriots in LawTube recognize me as being particularly knowledgeable and particularly expertise in Supreme Court, which I appreciate their collective judgment in that respect. So it's very nice and validating.
Very cool. All right, well, we're going to pull up your channel just as a reminder to everyone. Guys, Kurt on civil law, help him get to 150,000 subscribers.
You see this video that I did here where I discussed Trump's immunity? It took me 6 hours to discuss Trump's immunity.
Stream.
6 hours to break that decision down.
Oh my gosh.
I'm not messing around.
So if you are looking to get in-depth, like really in-depth legal analysis, I think Kurt's channel, you've been covering Karen Reed. Okay, you did some Amber Heard stuff. You also collaborate frequently with other attorneys. So there's a lot of, and that's something I think other niches could really take a lesson from the LawTube space with all of the collaborations and doing that kind of thing. I think more communities could benefit from that type of, of style, and I would love to see more of that. I think actually that, in my opinion, that's one thing that's made the quote-unquote LawTube
Are you not subscribed?
Successful. I am with my other channel. I apologize, Kurt.
I just helped noticing that it says subscribe there.
I'm sorry. I subscribed. I have a couple channels, and I do subscribe on some of my other ones. All right. I just subscribed with Sewing Report Live, so we're good there. I know. I'm so embarrassed, Kurt. I'm super embarrassed about this. Oh, my gosh.
The disrespect.
All right. Well, now you have one more. I think I've subscribed you multiple times now.
There you go. Okay.
So you have multiple subscriptions for me, and I do like to watch your streams. And I think y'all are doing. I think just what you've brought to YouTube is just incredible. Mm-hmm. And I really have just a ton of admiration for the whole. I know people find LawTube cringe. I'm gonna call it LawTube.
Do they?
You know, but like some people don't like.
Why do they find it cringe?
I don't know. Some people just don't like calling it LawTube. I don't know. I think.
Well,
that
I
makes
appreciate
sense
the
to
name
me,
being a bit cringe. I appreciate that. But
not the people, just the name. Like just
like
the
if
name.
it's like is the concept cringe? Like
I
whatever
think-
name we give it, arose by any other name.
I've heard. I'll just say I've heard certain attorneys say they do not like the designation. I guess I don't know.
Oh no, I appreciate that if they don't like the
Okay.
name. I understand.
Just they don't. Not. It's not. I'm not saying the thing is cringe, but people. I've heard people say they do not like the name LawTube and they don't want to be like part of a community or something. But in my opinion, that's what's made this whole genre really popular. I think it's
critically important.
Yeah.
I think rising tide raises all boats. You know, even Mr. Beast has commented about this. He's said that, you know, some people will say, I'm not supposed to share my secrets with other people, you know, because I want to hold on to them. And it's like, that's just fundamentally wrong. And I tend to agree with him. It's like, let's all learn from each other. We can all learn faster. It's like if there's 5 of us and we're all sharing our understanding about what's going on, we're all going to learn 5 times faster. So it's to our mutual benefit to share. Plus, I just enjoyed the collabs on its own basis because I like these people.
Yeah, no, there's you guys have had some real fun streams. I enjoyed them immensely. And you know, it's interesting because in some communities there is a lot of competitiveness and people like don't want to, you know, it's like they don't want to help each other out. I don't know. I don't really get it. You know, I try to help people out as much as I can. And, you know, it is kind of, yeah, it is disappointing that there's not more of that going on. So I think the LawTube genre really has figured out sort of a formula for success. And it's really helped a lot of the creators to grow and, you know, become full-time and do this full-time. And, you know, there is some good money in it if you can figure it out and get good at this. So I think this is awesome. So I'm so happy
I do
to talk to
okay.
you.
I don't have to starve. I'm not starving mode. But some of my fellow creators really rake it in. They do.
Yeah, there is
lots
potential.
Of
yeah, this could be a very lucrative. I'm probably more like middle class YouTube myself, but yeah, this can be a super lucrative way to make a living if you can.
You got the YouTube play button behind you. You're doing all right.
I do have the YouTube play button, so there's that. There is that.
I mean, that puts you in the top 0.3% if memory serves correctly.
Yeah, that does. You know, and that is a really, you know, it kind of seems like everybody's got a play button, but they really don't.
No.
And you're like, okay, well, I'm at like 0.2%, or I don't know, however it is, but
I think the last time I saw the numbers, it was 0.3%.
Yeah,
so
not
you're doing
a lot
better.
Of people.
You're doing better than 997 out of 1,000.
Yeah, no, that's awesome. And sometimes, like, you can kind of feel like, well, my growth has been really slow, but at the same time, you know, you got to be grateful. You have to be grateful for what has, for what's transpired and for the growth. You know, a lot of people just never make it here to begin with. So,
sure.
You know, I think some people, I think comparing yourself to other people is not healthy.
Comparison is the theft of joy.
No, it really is. It really is. So I really try to kind of just focus on what I'm doing and not really worry too much about like where so-and-so is or, you know, if my channel's not growing as fast as this other person, because your journey is your journey. So,
yeah.
All right. Well, Kurt, thank you so much for taking time out of your busy schedule. And guys, go over to Kurt's channel. He's going to be covering the Alec Baldwin trial. So
yeah, it's going to be exciting.
Yeah, that's going to be crazy. And I hope you all enjoyed this collaboration. I feel like I'm kind of a LawTuber now, but not really. But maybe we'll do more of this.
One of us.
Maybe we'll do more of this in the future. So Kurt, thank you so much. And guys, let us know what you think about this video and subscribe to Sewing Report Live if you would like to see more of what's going on in the world of sewing and crafts. Again, thank you so much, Kurt.
No worries. Thank you. It's been fun.